All right, welcome back to the Elias Macco Show. We're tackling a legal milestone here in Quebec. For the first time ever in this province, a court has reduced a prison sentence by nearly a year in this case, explicitly citing the accused status as a racialized individual and the systemic discrimination he reportedly faced. The government has criticized this as a dangerous precedent. You may have heard the minister responsible for the fight against racism, Christopher Skeety, joined us at 9:30. He's criticizing this decision, calling it a sad first. Let's get the take of a defense attorney. Tiago Murias joins us on the line. He's from the firm Ameur Múrias. Tiago, welcome back to the program.
Hello, thank you so much for having me.
What's your take on seeing a first of its kind ruling here in Quebec?
Well, it's first and it's not first because we're doing it for Indigenous persons for decades now. There's a Supreme Court decision, Gladu and Epili, that says that, Indigenous persons face systematic racism and the court must take that in consideration. And the criminal code was amended a few years ago to add to the Indigenous status people that were historically facing discrimination in regards of bail release or in regards of sentencing. So it's not something that is groundbreaking for jurists. I mean, it's coming for a couple of years now, and in the other provinces, it's something that is casually done, and it's something that is, you have data to show that it's based on science. It's based on numbers, and it's based on actual research that shows that there is communities, homeless people, for example, are historically face a disadvantage in the criminal system. That's another example of another marginalized group. So it's based on science, it's based on numbers, it's based on research. So there's nothing really shocking for me.
Okay, so I'm glad you brought up the Gladu program and the Gladu ruling that changed a lot of this. The recent change here, this is the impact of race and culture assessment. That's the additional tool here.
Correct.
That's at a judge's disposal?
Yeah, that is correct. It's physically extending, but it's in the criminal code too. It says Indigenous person, and now it was added in some section of the criminal code and other historically marginalized groups that face a disadvantage in the criminal system. So it's broader, It can include racialized people, it can include homeless people, it can include other marginalized groups that are up to the discretion of the courts, and it's still to the discretion of the court. So Gladu is mandatory, right? Gladu, it's mandatory. Indigenous persons, it's mandatory. But now judges have discretion to they may, in some cases, and I want to stress one thing. It's not all black people that will have reduced sentence. I want to make that very sure. Let's be very clear. In some circumstances, with some individuals where there is evidence that they faced systematic factors. And in the case of Mr. Prince, which is the person, Mr. Paris was in the person that was in this case, there was an evidence that was showed to the court. No, it's not the court out of his hat. It's evidence that was shown to the court.
In this case, the person that was sentenced, Frank Paris, 24 months in prison for trafficking hash and cannabis. So what I guess I got to get to is, why do you think it took so long for this mechanism to be used in Quebec?
That's because we have, different legal traditions. It's the same criminal code, but in Quebec, is a société distinct, as we say, for the best and the worst. I could add. There is some legal traditions that take longer to cross the bridges. Let's put it that way. So that's my very short answer to that.
Okay. Yeah. Now, I want to talk, because you mentioned before in the answer, we have data and that kind of thing.
Yeah.
And so under the Gladu principle, right? Now it's been many years since the Gladu principle came into effect. Do we have any data on the outcomes of that? Have things gotten better in the Indigenous communities across this country that we can point that's thanks to the Gladu principle?
It's sad, but not really. Because the weight of the systematic factors is so important that even with the principles, let's say if you took the number of indigenous people per capita that are incarcerated, it's still huge. It's still a number that is outrageous when you compare it to Caucasians, for example. Mm-hmm. So unfortunately, the answer is the road is a long one. And the same thing for, racialized people. When you see all things equal for the same crime, a black person will be more incarcerated than a non-black person. So this is, it's data. It's available. It's available for everyone to see. So unfortunately, the answer is no, yeah. And it's even worse for young people, indigenous people.
So we're with Tiago Murias, a defense lawyer with Ameur Múrias. We're talking about this ruling in a Quebec court, sentencing decision in a Quebec court that reduced a sentence for a racialized person by nearly a year. So Tiago, listen, this leads me to, I think, a difficult question. And, you're a lawyer. I need to ask it here. If it hasn't led to better outcomes, okay, I've heard the argument, and I have to say I'm partial to it, that we have to think about the victims of these crimes. And, in the case of indigenous communities, since we have so many years behind us here with the Gladue principle, with indigenous communities, if you look at murdered indigenous women, the number, I believe, is 86% of indigenous women murdered by indigenous men. And the argument can be made that, a tougher sentencing will help people in that community. What do you say? What do you say to that end of things?
It's not unreasonable. It's not an unreasonable debate to have. Honestly, I wouldn't be telling you, that's not, and it's a reasonable debate to have because the data you're quoting, it's actually a true one, and it is an issue. So I think maybe there is a discussion to have about that. I still believe that the principle of tailor-fitting sentences for marginalized individuals, it's a good one. But yes, we cannot just be blind to the systematic rate of homicides in the indigenous communities. And yes, maybe there is a debate to have on that. I will be very honest with you. And I think it's not an unreasonable debate to have.
Can I ask you, because, I had a comment from a listener in the first hours like, hey, listen, This was a charge for a hash and marijuana, okay? Mm-hmm. They still got 2 years, 24 months. That's still a big sentence in this country. It's not like they got reduced time on murder, right? That was one of the thoughts I got. I just want to know, let's say it's murder. It's it's rape and that kind of thing. Do these principles still apply? Is that being used in this country for really serious crimes as well?
It's a very good question. I would say the impact of the reducing will be less. There is a very strong jurisprudential current that says if it's a very violent crime with a very serious gravity objection with victims, then the impact will be reduced or will be looked in another way. That's the first thing. Second thing is, the one of the reasons why racialized people are more in detention is because of drug charges. Let's be very clear. The numbers are here. It's mainly because we give very harsh sentences for drug-related offenses that marginalized people are more in detention. So we must take that in consideration as well. So to answer your question, yes, it's different, but also let's remind ourselves that the fact that we give, as your listener said, very harsh sentences for drug-related offenses is maybe another debate to have.
Tiago, listen, this was a great discussion. I really thank you for bringing your perspective to the show today. I think it was needed. Thanks so much.
Yeah, no problem. My pleasure.
That's Tiago Murias, a defense lawyer with the firm of Ameur Múrias.